rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in 4 cases this morning. 3 of them are consolidated, and they're first. One is 21-1079, Abbott against the City of San Antonio from Bexar County and the 4th Court of Appeals District. Then 21-1080, Abbott against Jenkins from Dallas County and the 5th Court of Appeals District. And third, 22-124, Abbott against Harris County from Travis County and the 3rd Court of Appeals District. The court has allotted 30 minutes for each side in those 3 cases consolidated for argument. And then the second argument will be 22-227, In Re First Reserve Management, petition for writ of mandamus from Orange County and the 9th Court of Appeals District, and the court has allotted 20 minutes per side in that case. Justice Lehrman cannot be present this morning, but expects to participate in the decision of all these cases. The arguments are being webcast live this morning and will be available in the archives later today. We'll take a brief recess between the first consolidated arguments and the second argument. We're ready to hear argument in 21-1079, 21-1080, and 22-124.
May it please the court. Ms. Pettit will present argument for petitioners. Petitioners have reserved 8 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. These cases involve a number of overlapping statutory and separation of powers issues. I'm going to structure my comments today around what we think is the most efficient and constitutionally sound way for the court to address them. Specifically, I'm going to focus my discussion of GA 38 and its preemptive effect under the Texas Disaster Act on the claims by Harris County against the Attorney General. To the extent I have time, I will then turn to why the claims against the governor and the state should be dismissed for lack of standing. Harris County has not stated a viable claim against the Attorney General, let alone established entitlement to a temporary injunction, because GA 38 was validly promulgated, remains validly enforced, and is validly preemptive of contrary local orders. It is validly promulgated because the Disaster Act assigns the governor the responsibility to meet the dangers to the people and to the state of disasters. And as any legislative delegee, he has any powers expressly delegated to him or necessarily implied to fulfill that responsibility. The most clear express delegation for GA 38 is section 418.018C, which allows him to control occupancy of premises in a disaster area.
Is it your position that the governor can issue any orders that he finds necessary and proper to respond to the disaster, or do they have to fall under ingress, egress, or one of these other specific grants of authority in the Disaster Act?
Neither, Your Honor. Specifically, there are specific grants of authority, and the governor cannot use his general power under 418.012 to evade the limits on those specific powers, but 418.012 is a separate and independent grant of authority. And what he is allowed to do with that is guided by the other provisions of the Act. So here, the court need not reach the second aspect of it, however, because a mask mandate and whether somebody does or does not have to wear a mask to enter a building is a form of control of the occupancy of that building, similar to if you were required to wear a hard hat after a hurricane.
just about everything that we do every day involves the movement of persons and the occupancy of premises. And so in a statewide disaster of indefinite duration, the power to control the movement of persons and the occupancy of premises is, in many ways, plenary legislative power, particularly when the disaster is one in which our movement and our occupancy of premises is thought to affect the severity of the disaster. I wonder what is outside, what human activity during COVID is outside of the scope of this power.
So, for example, this court also dealt with a separate COVID issue involving the Anti-Defamation League of Austin against Abbott, which involved elections. And the elections issues, there were other areas of law that were in play, and that case could not have been resolved purely under the basis of occupancy. Occupancy of a premises, however, is a very broad power because because disasters can have buildings, have a lot of impact on buildings or other types of areas. I would note that if Your Honor is concerned about that particular issue, then the mask orders issued by the county judges here fall as well, because those are based on 418.108G, which is the same delegation of power. But the concern about the very broad delegation is ameliorated not just by political checks on the governor's ability to exercise it in that manner, but also the numerous enumerated purposes of the statute in Section 418.02, as well as the numerous other powers that put limits, because again, he can't use a broad power like 418.018 to evade the limits of the other powers in the Act.
You mentioned that other areas were in play, such as election law.
Mm-hmm.
In the other case you were referring to, isn't that the case here as well? Because we have Chapter 81 of the Health and Safety Code that relates specifically to public health disasters. So why isn't that the relevant body of law we should be looking at?
So Your Honor should look at that, but you should also look to 418.012, which gives the governor the power to issue executive orders that preempt local orders under that particular section.
So I'm not sure that we need to get there. Let me lay this out for you and see what you think. Chapter 81 of the Health and Safety Code says that local county health authorities have supervisory authority and control over the administration of communicable disease control measures in the health authority's jurisdiction unless specifically preempted by the department.
Yes, Your Honor.
The Department of State Health Services.
Yes, Your Honor.
And then the very next provision says that the Department of State Health Services, so it says a communicable disease control measure imposed by a health authority in the health authority's jurisdiction may be amended, revised, or revoked by the department.
Yes, Your Honor.
So that first provision seems to excuse me. Sorry.
No worries.
That first provision seems to give the health authority sorry.
The first provision does seem to give the health authority a grant of power, but it is limited by the second, which actually negates some of the plaintiff's assertions.
So the first provision seems to give the health authority control over the other local officials. And then the second provision, I'm so sorry.
So
I've got something in my throat. It gives the department control over the local health authority.
Yes, Your Honor.
And then in a disaster, the governor has control of the department.
Yes, Your Honor.
So it looks to me like under Chapter 81, the state can control the local response to contagious diseases, quite apart from the Disaster Act. The state health department can tell local health authorities what to do, and then the local health authorities have power in their jurisdictions to tell the other local officials what to do with respect to contagious diseases. And then all the Disaster Act needs to do is make the governor the commander-in-chief of state agencies. And so once the governor is sort of running the Department of State Health Services by virtue of that provision of the Disaster Act, he can use the department's authority under Chapter 81 to control the way the locals are responding to contagious diseases?
Yes, Your Honor, and to a certain extent he has done that. The reason why the GA 38 is written in the way that it is that it's actually the second or third iteration of the same type of order trying to resolve the issue of local governments who were trying to write their way around prior executive orders, which created confusion for the people of Texas who have to know what they can and cannot do. And so the Disaster Act, or so the GA 38, has a bit of a belt and suspenders approach that says, under the ingress and egress provision, we are saying no masks. That is preemptive under 4180.012. To the extent these other statutes are at issue, they are also suspended. And not all of those are independently legally necessary because they are all legally sufficient, but they do make clear that the governor's order is what controls in addition to the reasons that Your Honor just laid out.
So I didn't see this in the briefing. This, if it's right that under Chapter 81 that the state can control the local response to contagious diseases apart from the Disaster Act, and if it's right, therefore, that the only work that the Disaster Act needs to do to give the governor control is to make him the commander-in-chief of agencies such as the Department of State Health Services, that seems to be a simpler and less constitutionally problematic avenue than much of what has been briefed. And so I wonder whether you might take a look at that and let us know, both sides, let us know what you think about that source of authority.
I'd be happy to, Your Honor. So I do think that that's right for the local authorities who've relied on that particular chapter. Now, a number of the other authorities have relied, including Harris County, on Chapter 121, which may not be subject to the same provisions, and in that case, you may need to get to the Section 418.012, which gives preemptive force of, or in the terms of the statute, force and effect of law to the governor's orders. And one of the effects of something that has the force and effect of state law, because it is a state actor pursuant to a state delegation, is that it preempts county and city rules. Under counties, it's because the counties, in addition to the provision that Your Honor was just discussing, always effectively act as the arm of the state because they have no separate sovereignty. For home rule cities, the only one of which is the city of San Antonio, which doesn't have standing for a reason I'll discuss in a second. It has any authority not granted by the legislature, which may be the biggest issue with resolving the case on the way that you're talking about, because that provision is specific to local health authorities, whereas the cities have independent authority from the Home Rule Amendment itself to the extent not contrary to state law. Now, we still think that because state law has that preemptive effect under the Constitution itself, as this court explained in Laredo Merchants Association, you get to the same place, just not necessarily through the same route.
Well, and if the county health authority has supervisory authority and control over disease control measures within its jurisdiction, and I would think that a city's disease control measures are just as much within the jurisdiction of the county health authority as anybody else's, and therefore subject to the county health authority's supervisory control.
I will defer to the city of San Antonio to see if that's how they've set up their system, because the local public health authority is not a requirement to be appointed. And I believe that there is one that serves that way in the San Antonio-Bexar County area. That's all the court needs to decide here, but I don't know that for sure. And so if the court does not choose to resolve it on that, it can choose to resolve it on the preemption grounds that we have briefed. And as to the constitutional concerns on the delegation is what I think Your Honor is referring to. That is just that under FM properties is looked at as a statute, as a facial challenge to the entire statute, not to a particular executive order issued under the statute or a particular application of it. And the statute itself, as both Harris County and Dallas counties, the courts of appeals, recognize as a very detailed, comprehensive statute, and so as a whole gives sufficient guidance as to when it can and cannot be exercised to satisfy this test for public non-delegation doctrines, which has existed since the 1940s in a case called Higginbotham, because that allows delegations of this type where, and I'm quoting here, the legislature cannot practically and efficiently exercise power or where the conditions to be considered cannot be easily investigated by the legislature. That is the situation in the Disaster Act, because the Disaster Act is designed to create a framework that can be used for everything from extreme heat to nuclear war. And it's impossible for the legislature to predict in advance what the governor or anybody else for that matter is going to need to do to respond to such a wide variety of issues. It has selected the governor because he is the chief executive of the state, and it gives various powers and various tie-breaking powers to the governor to ensure, in the words of the El Paso court, that there's one captain of the ship, or another nautical metaphor, that we're all rowing in the same direction. Because again, the people of Texas have to know what they can and can't do during a disaster, and that is why the governor has control.
So that makes sense for a disaster of a duration such that the legislature is unable to meet.
Yes,
GA 38 came out a month after the legislature met. And should that make a difference, that the legislature had the opportunity to meet and to consider all of these issues and all of these public health issues? Should that make a difference to whether or not there should be some limitation on the power granted to the governor under the Disaster Act?
To the extent that it should, it's because the legislature decided not to terminate the disaster as it could by law. And so I won't go so far as to say the legislature ratified everything that's gone on during the disaster, because I think that's a bridge too far. But the legislature did meet and did have the opportunity to consider the delegations and how the governor had been using them, and opted not even to vote on whether to, as I recall from 2021, to terminate the disaster. So at that time, it seemed like, that seems to reflect the legislature was okay with this. And so that is how I would interpret that. In terms of the standing issues that I've alluded to briefly, I'll turn to them now unless the court has any other questions regarding the Disaster Act itself. And that is that the Harris County has brought a claim against the Attorney General and the governor. The standing question as to the Attorney General is admittedly very difficult, because the Attorney General has sent a letter specifically to Harris County saying that if you continue to enforce your unlawful ban, then it will be enforced. This court has never addressed whether a threat of a declaratory judgment action by itself is sufficient for a pre-enforcement standing, but I don't think the court needs to get to it, because there are lots of other ways to resolve that claim against the Attorney General. The governor and the state are in a different position. The governor has no enforcement authority under the executive order for the exact same reasons this court decided in Ray Abbott in the second half of the opinion about the enforcement challenge, as opposed to the first half of it, which was it was an actual existing injury to a dilution of power argument. There were two different sections of it. The governor doesn't have enforcement authority. Enforcement authority is required to have standing in a pre-enforcement challenge.
You've said several times that the governor in the Constitution, Article 4, Section 1, is the CEO of the state, and the very act that we're talking about makes him the commander-in-chief. So it seems like he has a lot of authority in this context, at least, and whether it's enforcement in an ordinary sense or not, I don't know, but this is not as though he's just sort of over there powerless.
Certainly, Your Honor. And if there had been some specific concrete action that the governor had taken, for example, calling out the National Guard, assuming that is not a non-justiciable political question, that might be, if that had caused a direct injury, might be enough. But in this instance, where it is a pre-enforcement challenge to an executive order, this court has already looked to whether or not he had enforcement authority under that order in Ray Abbott, and he did not. And the court reaffirmed that in the Malk case in late last term about that one was a redistricting case where the governor.
So just in terms of thinking from first principles, though, is it wrong to think that people like those who are here before us today were injured in an Article 3, Article 5 for our Constitution sense by the executive order purporting to divest them of authority that they think that they have in order to respond to a disaster?
So Not from arguing from first principles, because arguing from first principles, the dilution of power for a subdivision of the state by the state isn't a cognizable injury.
So if they think that they have some authority to do something, that they will be in serious potential criminal violation if they do it, does that count as a mere Article 3, Article 5 injury?
So if there is, so normally this court, and you refer to Article 3 because you do look to Article 3 from the federal Constitution, ordinarily there's no presumption of a pre-enforcement challenge. So under that circumstance, outside of the limited circumstances where pre-enforcement is deemed appropriate because there is that threat of a significant criminal penalty, then there's no pre-enforcement challenge at all. You have to wait, and then when the enforcement action is brought, you challenge it then, to avoid putting this court in a situation where it has to determine the validity of the law with no facts, effectively.
Does that mean there's not an injury?
That means there's not an injury. That is usually established. It's the sort of hypothetical injury problem that is talked about in Article 3. So if there is this all started with Steffel against Thompson in the 1970s, and the phrase that was used there was non-chimerical risk is enough to say the injury hasn't happened yet, but there's a substantial enough possibility that it will happen.
So does the governor not regard the GA38 as having an effect of limiting the the counties and cities' authority at this point? I thought otherwise, but.
So he certainly, under 418.012, it certainly has the effect of preempting their order. It does not limit their authority to do other things, but it limits their.
What about the suspension?
So the suspension is written in a way that it's just to the extent necessary to make it effective. So it doesn't suspend the Chapter 81 that Justice Blacklock was discussing in its entirety, just to the extent that that is being used as a way to create a rule to write around what would otherwise simply be preemption. So the original version of this executive order, and I'm sorry, I don't remember what number it was, didn't have the lengthy suspensions. It just had this, and I believe that particular one was written in terms of a business closure. That it was, these are not allowed. And then a bunch of local authorities nonetheless created orders citing authorities outside the Disaster Act, and in subsequent executive orders, though it was to make sure that the people of Texas knew what they could and couldn't do, the governor said, okay, to the extent you're relying on these other provisions, in his view, they were already preempted, but just to be clear, those are suspended to the extent necessary to make the order effective.
So if we conclude that that is some loss of authority, what's the best case to say there's nevertheless no standing, other than Abbott, which involved a threat of possible prosecution?
So here the enforcement mechanism is a threat of a civil fine. So it's the same general enforcement mechanism as Abbott.
And so you're saying that there's no loss of authority until it's enforced?
So there is, the loss of authority by itself is not a cognizable injury.
And why is that?
So In re Abbott discussed that that's a separation of powers issue that the courts are very, very reluctant to do, and the mask order itself here acts like that order did there on other people, typically, the people who would have to be wearing masks. And so that it may affect the specific ability of the local authorities to act within what would otherwise be their power, but that standing by itself was not an injury. Even if it was, it wouldn't have the traceability element, which is where the enforcement comes in, not so much the injury. The enforcement and the power to enforce comes to whether it is traceable to the governor as opposed to the promulgation of something that is effectively a law at this point.
On suspension, could I point your attention to 418.0155, which is a suspension list, and directs the governor to compile and maintain a comprehensive list of regulatory statutes that may require suspension. Is that a limitation of sorts that cuts against what you've just mentioned? Does the list exist?
No to the first, yes to the second. So the list does exist. It's not required to be and is not because it's routinely updated, published in the Texas Register. If Your Honor would like a copy, I would be happy to provide it to you. the section itself is written in informational purposes, and in this court's language in other cases, mandatory versus directory, and whether or not that's judicially enforceable, it would be in a directory sense because he is required to do it under the law, and he has to abide by the law for the reasons this court explained in Ray Stetson a couple of weeks ago, but that doesn't mean that it's a judicially enforceable mandate. I see that I'm out of time. Unless there are other questions, we request that you reverse, and I'll be back in a few minutes.
I have one question. To follow up with Justice Bland's question, how do you reconcile all of this with Article 1, Section 28 of the Texas Constitution?
The suspension clause, Your Honor?
Yes.
So the suspension clause, in the context it was written in 1876, apparently appears to refer to the declaration of martial law. And this is not that. Now, in terms of suspension beyond that, it then comes to the question of what the term suspension means and if the suspension in that section goes beyond. I don't think it does. I understand that Your Honor is concerned or has expressed concern about the Cracker case from 1911. So that talks about a very specific type of suspension, which is actually what they're saying they have the power to do here, which is reverse preemption, that a city can preempt state law because the legislature has allowed them to do so. That particular type of suspension has been resolved definitively by the Home Rule Amendment since the Cracker case. Now, in terms of other meanings of suspension, I think the best way to understand this one is where there are horizontally types of law that would otherwise be, the court would have to decide which of two equal laws trump when they are in conflict. The legislature has used the suspension clause to allow the governor to make factual findings that under those circumstances, his executive order trumps a statute during the dependency of the disaster. That's what I think the suspension clause here is best understood as. And to see another place where a statute uses suspension in that sense, I would point, Your Honor, to Texas Government Code 659.033.
So did you say that you think that the suspension clause refers or prohibits the kind of general suspension of law that would take place in martial law and not the kind of specific suspensions that are at issue here? Is that what you think?
Yes, Your Honor, because the way that it's written is written in a way that, if read literally, would mean that because it just says laws in this state, would mean that a local ordinance couldn't be suspended by anybody other than the legislature, and that really can't be what it meant. And that's this. And I would also point, Your Honor, to the separation of powers clause, which does a lot of the same work, which is effectively a suspension of the law outside of that context is really just a legislative amendment. And that can't be delegated, but you can delegate the ability to determine facts on which that law depends.
I wonder whether the lockdowns in 2020 would have qualified as the suspension of law in the general sense that might be prohibited even under your understanding.
I don't think so, because the lockdowns did not end in martial law. Civil law as we know it does not apply and doesn't exist. Now, in the lockdowns, people couldn't move, and that is akin to a quarantine, but they were still subject to things like criminal laws or tax laws or that sort of thing. The laws were still in effect. They were just less likely to be enforced because people were not leaving their homes.
What's the authority that governs what happens if the governor declares martial law?
I'm sorry, Your Honor, I didn't hear you over Justice Hex clearing his throat.
What's the authority that governs what happens if the governor declares martial law?
So the governor can't declare martial law under the Constitution. If the governor were to do so, that would be a very difficult question because there might be a non-justiciable political question at that point.
So 418.003 says nothing in this chapter limits the governor's authority to declare martial law. And I think the Transportation Code has a similar provision and yet nothing else in any statute or in the Constitution ever refers to martial law.
So
where's that authority come from and what governs it?
So I believe that is an error that was included because this was adopted from a model statute that was applicable to all states. And so I think that provision also says other types of authority, not just martial law on the governor's part. So I don't think that particular phrase applies really in Texas. And that
in other words, you don't think that the governor has authority in Texas, any authority in Texas to declare martial law?
So he has the authority under, I believe it is Article 4, Section 7, to call out the militia under certain circumstances, which has very similar practical effects to declaring martial law when it happens. But I don't know that it would actually have the effect of suspending the laws in the way that I was just discussing. There would be military forces that were being used for particular purposes. I believe putting down insurrection is one of them. And that is a circumstance where the law really doesn't have much force if you're using the military to put down an insurrection. But I think the laws would still technically be applicable. They just couldn't be enforced because of the civil unrest at that point.
So the answer is correct. In Texas, in your view, the governor has no authority to declare martial law.
Indeed, and the attorney, that's been the Attorney General's view since I believe an Attorney General opinion issued in like 1939.
And so 418003 is just accidental surplusage from the Model Act.
Those particular pieces of so
That part of it,
those
martial law
words,
lesson.
martial law. There are other parts of the governor's authority that particular section talks about that are certainly applicable in Texas. But there is he has no power to declare martial law, and so therefore a language that says that this does not reduce power he doesn't have any effect in Texas.
Any other questions? Thank you, Ms. Pettit. We'll hear from the respondents.
May it please the court. Mr. Alexander, Mr. Fambon, and Mr. Cradiville will present argument for respondents. Each counsel will argue for 10 minutes. Mr. Alexander will open with the first 10 minutes.
May it please the court, I'd like to go directly to the question you asked Justice Huddle about 418.0155. I think that answering that question will also help address a question by Justice Bland about the limits on the governor's authority, as well as questions by Justice Young and Busby regarding injury. So let's focus on, I've got a handout, let's turn to tab 3. So the governor has been delegated a power that was greater than any power delegated under the Disaster Act, either to local governments or to this court. So this court had the authority, for instance, to suspend procedures for the operation of courts. But the governor alone was given the suspension power to suspend statutes. There's actually under the previous tab, did I say tab 3 or tab 4?
3.
4, please. So tab 3 that you just looked at are 6 different suspension powers that were given to the governor. Tab 4 is the suspension power that the governor invoked for issuing GA 38. Okay, this is it. The governor may suspend the provisions of any regulatory statute prescribing the procedures for conduct of state business. Now, when you asked Justice Huddle about 418.0155, that immediately precedes this provision. And it requires state agencies to keep a list of regulatory statutes that could pose roadblocks to disaster response. For instance, let's say you had a regulation that says you can only have 2 hospital beds per room. What the state agencies would do is to say, okay, that needs to be suspended. I mean, if we've got a disaster, we've got to pack cots into hospital rooms, we need to do that. And so the governor needs to have the power to suspend a statute or a regulation that would do that. But now let's look down at the bottom. This is GA 38. Let's look at what the governor actually did. This is drawn straight from the order. To the extent necessary, I hereby suspend the following. It's a whole raft of things. Let's look at the last one. Any other statute invoked by any local governmental entity or official in support of face covering requirements. Now, the problem with that is that just as this court was delegated authority under the Disaster Act, and the governor was delegated authority, so were local governments. One of those ones we invoked was 418.108, which is the mirror image of the statute that the governor invoked, for instance, for GA 29 when he did a statewide mask mandate.
So you're arguing that there may be infirmities in some of the authority that the governor has cited under the Disaster Act, but what I think you need to address is 418.1015B, which says that county judges and mayors serve as the governor's designated agent in the administration and supervision of duties under this chapter. And so that sure reads to me like anything a county judge or a mayor who are designated as the emergency management directors for their jurisdictions, anything they do under the authority of this chapter seems to be done in their capacity as the governor's agent, and therefore subject to his control on that basis alone, whether or not you're right about some of the other arguments you're making.
Okay, so I disagree with that. So look at 418.108, which is the authority under which the Judge Jenkins acted here. That's what allowed him to issue his mass mandates. There's no mention of the governor in section 418.10.
But that's a duty under this chapter. I mean, the governor you're the governor's agent in the administration of duties under this chapter, and you're citing a duty under the chapter as the basis for your action.
Okay.
And if you are the governor's agent in the exercise of that duty, then surely he can tell you to stop.
Two different things. So we have 418.108, which independently empowers local governments to act and makes them, if you look at tab 1, let's look at that. This is the structure of the Disaster Act. It makes at the local level, the county judge, the commander-in-chief of mayors. It gives them inchoate powers there. The provision you're talking about is the separate provision that makes the local officials the agent for the government to act for the governor at the local level. And that's recognizing that in a state with 254 counties, we don't have the governor taking all the shots on the basketball court. He's passing off the ball for many of these things to county judges to shoot baskets as well. So that it's not a limiting provision. That's what's critical to understand. There's nothing about, in fact, if anything, it's granting authority. It's giving the authority of the governor to the local officials at the local level to act appropriately. That's completely independent.
Giving authority to the agent to act contrary to the desires of the principal?
This is, once again, if you ignore 418.108, you're right. If we strike that out.
Well, I'm not ignoring it at all. That's a duty under the chapter, which is, and when acting in that capacity,
it's not a duty.
It's the governor's agent.
With all due respect, it's a grant of authority. It's an
It's a grant of authority about local disasters, declaration of a local disaster. We're talking about a statewide declaration. Is that not in itself something that suggests there's a higher level of authority once the governor says there's something statewide? How can we have someone say, no, the same thing as a local disaster if the governor's called it a statewide disaster?
Well, let's look at Exhibit 1. So when you look at the structure of the Act, and this is strictly a case of statutory construction, there are 3 chains of command that were created under the Act. This is the prerogative of the legislature. I mean, we can return to the decision by this court in Laredo Merchants, the plastic bags case, where this court says it was the legislature's prerogative to decide whether to have uniform statewide regulation or to have a patchwork of regulations. In this case, what the legislature has done in its prerogative, it says that we are going to empower local officials to act locally, and that's under 418.108. We're going to empower the Texas Supreme Court to operate within the judicial branch. This court is the commander-in-chief of the judicial branch, and we're going to make the governor the commander-in-chief of state agencies, boards, and commissions. Not of the judicial branch, not of local governments. This is the structure the legislature chose as a practical way of addressing a disaster. If you look at let's look at tab 6.
There can be some local disasters that are not statewide, but there can be some disasters that are statewide, and thus you're now operating in your capacity as the agent of the governor and not focused as a a local authority running a local disaster.
Well, that's not the way it's structured. In other words, the way that again, we have to give force to what the legislature decided to do.
If the temporary injunction is affirmed, is the Dallas County judge going to begin to enforce and require masks in Dallas County?
Currently, no.
So
Because-
why hasn't the order been rescinded?
Well, for this reason. I mean, the way that the order is currently worded is that it is tied to CDC guidelines. So that if a flare, right now, CDC guidelines for COVID are green. And so in Dallas County, currently, if the temporary injunction were to be affirmed, there would be no mask mandates because CDC guidelines are green. If they spike up to to red, then they would come back into effect. I mean, that's
So right now, there's no inconsistency between the state law or the state executive order and the local order.
There's no practical inconsistency. In other words, currently, no mask mandate would be enforced in Dallas County. However,
By either the local authority or the state.
correct. But for temporary
But
injunctions.
you're asking us to nevertheless opine about who has the power, even though the
Absolutely.
result is effectively the same.
Well, it's effectively the same today, February 22nd. Let's say 2 months from now, there was a spike in COVID. This is not, that's not beyond question that could happen. In that case, under the order that's in Dallas County, mask mandates could be called back in effect for limited areas, as it is now. So we're not asking you to make some sort of advisory opinion. We're asking you to decide and I'll get back to the power. I mean, look at what the governor, let's go back to number 4. What the governor is seeking to do in his GA 38 is to act far beyond the suspension powers he was given. I mean, you'll hear in this very argument that the third speaker that this suspension authority tests the limits of the Texas Constitution. We're not making a constitutional argument. I want to make that clear. We are making a statutory construction argument, and we're saying that what GA 38 does is to suspend statutes beyond the regulatory types of statutes that are in 418.0155. You have to harmonize those provisions. Sure, he can get rid of or suspend statutes that would prevent disaster response, but he cannot disempower either this court or local governments from exercising power that they are expressly delegated by the legislature under the
If
Act.
there was a disaster that the governor says is statewide, and who knows what kind it is, but there's a particular kind of hat that he says everybody has to wear it in order to be safe. And it's the same disaster locally, and in Dallas County, the conclusion is nobody may wear that hat in order to be safe. Is it possible to have both a statewide and a local disaster operating at the same time in this structural argument about the legislature has given authority to the localities in that way?
Well, I mean, I think that would then implicate an actual conflict between two mandates, as I understand your question, and I'll quickly say that's not what we have here. What we have in our case is the governor actually disempowering local governments from doing that. But in your case, good question. I mean, I think that if we applied ordinary statutory construction principles, we would say in terms of that direct conflict, you would apply, there's no tiebreaker. I mean, let's go to tab 2. Under the Act, we have a tiebreaker as between a county judge and a mayor. We don't have one in the Act between the governor and a county judge. I mean, and we have to give effect to that omission. I mean, the legislature knew what it was doing. It consciously didn't make a tiebreaker. So in that case,
the state responds that the tiebreaker is that the governor's order has the force and effect of state law, and as a result, it has primacy over the local order. And we wouldn't even need to reach the issue of the suspension of laws, because both are acting with authority granted to them, but one's authority is superior to the others, and when they're in direct conflict, the superior order controls. Why is that argument not a response to?
Well, let me deconstruct that argument, because I think it's critical to really understand that. There is not much jurisprudence with respect to executive orders. There is with respect to administrative agency orders. And this is what this court has said in Lewis versus Jacksonville Building, 540 Southwest 3rd 307. Valid rules and regulations promulgated by an administrative agency acting within its statutory authority have the force and effect of legislation. The very question you're being asked to decide in this case is, does GA 38 have the force and effect of law? If it was issued beyond the statutory authority granted by the legislature, it does not. Period. Hard stop. It does not have the force and effect of law. That's the question before this court. And so to answer that question, you have to give effect to the power that was delegated by the legislature to these three different groups: local government, the governor, and this court, and ask yourself, could the governor issue a suspension provision that is so broad that it says, if you come up with any statute at the local level that allows you to do what the legislature authorized you to do, it's dead.
It seems
that
like
goes too far.
Maybe you need a fourth box on that chart under Chapter 81, because the Commissioner of the Department of State Health Services can tell the local health authority, no, you can't do that. It says it has preemptive effect. So if the governor is acting as commander-in-chief of the Department of State Health Services, then why isn't that a source of power?
Well, I mean, that's an interesting argument. I mean, I think that, and I don't have a good answer to that precise one. I would say, though, that when you look at the structure of the Disaster Act itself and give effect to 418.108, which doesn't have the word governor in it, doesn't have the word Justice Blacklock agent in it, if you give effect to that and then look at this and say, does the governor have the power to suspend that statute? The answer would be he does if it's a regulatory statute, but it is not. It is not.
If it's more, isn't the Chapter 81 more specific to the situation that we have here because it involves public health disasters rather than ingress or egress to buildings more generally?
Well, and happily, the Harris County would be stepping up here first because they invoked that. In Dallas County, we did not. We invoked 418.108, said that's the power that was granted. It's the same power that was granted to the governor that allowed him to do GA 29, his mask mandate. So I'll defer to my brother to address that question.
Thank you, Mr. Alexander. Any other questions?
Just a comment. Justice Blacklock earlier invited both sides to provide additional briefing on the Chapter 81 issue, and I hope both sides heard that. I think it'd be helpful.
Okay.
Mr. Chief Justice, and may it please the court, Jonathan Fonbon from the Harris County Attorney's Office for the Harris County parties. So I'd like to go back and answer that Chapter 81 question because it's an interesting one. And it tells us two things. First, that when the legislature wants to preempt local orders by statute, it knows how to do so. And it didn't do that here in the Disaster Act. And so the argument goes that because the governor is the commander-in-chief of state boards and agencies having responsibilities for, I think, emergency management, he could go in and commandeer the State Department of Health and Human Services to essentially preempt a local health authority order. Candidly, we disagree with that construction. The commander-in-chief designation is not a grant of authority, it's sort of a description of the governor's role in this process. And if you look at all the grants of authority in the Disaster Act, they say things like the governor may or shall or things like that. So again, I don't think—
Do you disagree that the department, let's set the Disaster Act to the side, under Chapter 81, the State Health Department has the authority to preempt local contagious disease control measures. Do you agree with that?
Absolutely. And in fact, I think it reinforces our preemption argument. So if I may, the state's preemption.
So the commissioner of the state health department could do what the governor has done. I mean, your position is that mask mandates are control measures.
Correct.
The state health department can control your control measures. So your position is that the state health department can do what the governor has done, but the governor cannot.
That's correct. And again, I don't think the commander-in-chief designation gives him the authority to go in and take those statutory grants of authority to the department.
But if the declaration of a disaster, if we disagree with you on that, and the declaration of a disaster makes the governor the commander-in-chief of the Department of State Health Services, essentially, we now have a unitary executive, and so he can just make dishes do whatever he wants to do. If that's how it works, it sounds like you would then agree that he has the power to ban mask mandates.
I think that if there was a specific grant of authority that allowed him to say, come in and have the exact same role as the Commissioner of Human Services or the department, he could use that power.
So if we think the commander-in-chief provision of the Disaster Act gives him unitary control over dishes, then you lose.
Well, we don't lose because there are two orders at issue in our case. So one is that local health authority order. The other is an order promulgated by the Harris County Commissioner's Court pursuant to powers that are not expressly preempted anywhere. And that order would still stand, and so the litigation would continue.
How would it stand if the powers aren't granted anywhere and the county is a subdivision of the state government and has to look to the state government for its powers?
So if I understand your question, so there is a grant of authority that allows counties to set conditions of employment for its.
Oh, I thought you said there was no grant of authority for the.
No, there is no express preemption anywhere in the local government code, the Disaster Act, or any other statute I'm aware of that creates an express preemption mechanism for some state agency or some state actor to come in and preempt the local government's power here, right? But I think that's an important point because the state's argument, again, is that 418.012 creates this general preemptive power. And I think that in their briefing, they've referred to the fact that we need to look at traditional preemption principles to understand how 418.012 interacts with other provisions of the Disaster Act, but also any other provision of state law that gives local governments powers to do things. And respectfully, I think I disagree with that. So first of all, there aren't really traditional preemption principles in Texas state law. There are really two. There's express preemption, which is when the statute says local orders are preempted, for example, as in Chapter 81. And then there is the preemption principle that's derived from Article 11, Section 5 of the Constitution, and that applies to municipalities' charters or ordinances. But that's just not what we're dealing with here.
Is that derived from Article 11, Section 5, or is that literally what Article 11, Section 5 says, that no local government enactment may be inconsistent with the laws?
No, I agree with you. It's derived in the sense that the jurisprudence of it is derived from that authority. So, but there isn't, as in the federal context, a kind of field preemption or conflict preemption analysis.
It's a supremacy clause, isn't it? Article 11, Section 5.
That's right. But so again, in Texas state law, however, these are the only two types of preemption that have been recognized. And so again, when we come back to county orders, there's no preemption principle out there in the ether or in the Constitution that grants state law any kind of preemptive authority over county orders. The only time that happens, obviously, is when the state law specifically preempts the county order.
Well,
so as in Chapter 81.
If the county commissioner's order is a control measure as described by Chapter 81, would you agree that it's subject to preemption by the state health department?
So yes, but again, that's not what the county commissioner's court did here. This was really, they were setting conditions of employment for their employees, and that's derived from a completely different grant of authority, which is the grant of authority to set salaries, and necessarily implied from that is the conditions of employment for their employees. And I'm not aware of any specific provision that preempts their authority to do so. So then you'd have to look to some other preemption principle, which we don't think exists here.
Well, we've said in the employment context that Chapter 21 governs county hiring and so in the labor code. So you're saying that there would have to be a specific employment statute that would raise a conflict, and so the executive orders just simply not enough to govern county hiring and firing in a particular instance?
Yeah, so what we're saying is that for state law to preempt a county order promulgated pursuant to another state law that gives a grant of authority to a commissioner's court, there would have to be a specific preemptive authority given to some state actor in some statute to do so. I'm not aware of one. And the legislature knows how to do this, not only just in Section 81, this appears in all sorts of other statutes.
Do you agree that in their capacity as an employer, the county must comply with state law in hiring?
Of course. But I don't think that's an issue here. There's no, and again, the other side has not at all argued that the county didn't have the authority to set a mask mandate for its employees while in county buildings. And what they simply say is, and I think their argument is, look, counties are an arm of the state, and when the governor issues an executive order, that has preemptive effect. And we just disagree with that contention. So for a number of reasons. One is, as my friend from Dallas said, there's not a lot of jurisprudence on executive orders, but I think what we see in the Disaster Act is that the grant under 418.012, it's not a grant of legislative authority. It's really a tool for the governor to execute on his other, on the other authority granted to him under the Disaster Act.
Does that position read out the provision that says that the governor's orders have the force and effect of state law?
Well, so first of all, that provision says that they have the force and effect of law. And I think that's been translated into state law by virtue of the fact that the governor is a state actor, which I agree has intuitive appeal, but force and effect of law doesn't actually do all that much work. So for example, political subdivisions can also issue orders that have the force and effect of law. So Texas Agricultural Code 201.103 says that conservation districts, which are political subdivisions, can issue orders that have the force and effect of law. That doesn't tell us anything about the preemptive nature of those orders. It just says that those orders can be enforced.
I'm not sure I understand the scope of your preemption argument. So if the county has an ordinance that says we're going to follow X procedure in hiring, and there's a state regulation that says when you hire any public employee, you should do not X. You would say that's not preemptive unless there's something specific in the statute that gives the agency the authority to preempt law on a county level?
So yes, and I think that,
even though there's a patent inconsistency between those two things.
Yes, but again, when the grants of authority the grants of authority to state agencies or grants of legislative authority, and those are necessarily imbued with the force of state law. And I do think when you have that conflict, you get closer to a preemption argument. I don't think you see that in the executive order context under the Disaster Act. It's nowhere in the Disaster Act. It's not in any other sort of principle of law or any of this court's opinion. So I do think there's a distinction between an executive order under the Disaster Act and a properly promulgated rule of a state agency pursuant to a statute that delegates them legislative authority.
You think the governor's declaration, executive order under the Disaster Act, has less force than an ordinary administrative regulation promulgated by some random department of state agents?
I'm not aware, the answer to that is I'm not aware of a preemption principle that would apply in this context. And I actually do think that the governor's executive orders, again, are simply a tool for him to execute on other authority. And they tell us nothing about the preemptive effect of those orders. And in fact, when you look at the structure of the Disaster Act, my friend from Dallas has said, there clearly contemplates two paths to response to disasters. And to the extent we need to have a tiebreaker, there's actually a lot of evidence in the Disaster Act that the legislature thought that local governments had essentially a primary role to play in responding to disasters, which I think we all agree are mostly local in scope, and obviously the pandemic is slightly different in that context. And if I may, I realize I'm out of time, but if I may, I'd like to respond to you.
Yes, go ahead.
One of the issues you raised, Justice Young, about standing here, I don't think we need to reach the issue of whether or not the local health authority or the commissioner in the Harris County case has a cognizable injury, because the county has one. At the temporary injunction hearing, there was testimony from the county administrator about the costs of COVID on the county. So he testified about $5.3 million in workers' comp claims, I think $7.1 million in excess insurance claims because the county self-insured. And that is a traditional Article III injury.
And the county should be heard as a unit of the state government to be able to go into the judiciary, which is a different branch of the state government, and sue the state
Yeah, I
that
think,
regard
well,
for that kind of injury?
well, with respect to that kind of injury, it would be no different than a county going into court and saying, you know, you've breached a contract with me, I have a financial injury. That's a classic Article 3 injury, and I can bring that claim on behalf of the county. And in fact, we do that all the time.
If the temporary injunction is affirmed, does Harris County Commissioners Court and Harris County Judge plan to enforce its order mandating masks?
I think my answer to that is exactly the same as my friend from Dallas County's, which is not right now, but COVID comes in waves, as we know, and we'd like the opportunity to be able to do that when there is the next wave. And we saw, for example, back in November, we were preparing to see a wave of infections coming from the East Coast. It didn't materialize, but I know that the county's Department of Emergency Management was getting ready for that and would have liked to have access to that to that policy.
So your pre-enforcement challenge to the governor's executive order, at least right now, is unnecessary because the county is viewing this no differently than the governor's executive order views it.
Well, to rephrase your question, which is there a live controversy between the parties? I think there is, so for a number of reasons. One, the governor himself keeps renewing the declaration of disaster here, and in fact specifically to enforce GA38. But two, the nature of the pandemic is such that if we take this narrow view of mootness, which I think is what you're suggesting, Justice Bland, we would be in a world where there would never be review of these orders. There would never be the opportunity for this court to essentially pass judgment on what the Disaster Act means. And that's very close to the capable repetition evading review doctrine, which we would say maybe doesn't neatly fit here, but certainly should be considered in this context.
Any other questions? Thank you, Mr. Fonbon. Thank you. Mr. Cradaville, we'll hear from you.
Mr. Chief Justice, and may it please the Court, Chris Cradaville with Dykema on behalf of the City of San Antonio. The focus of the city's argument is GA38's suspension of multiple statutes enacted by the legislature, including a sweeping declaration, and I want to quote this language because I think it's important. It's so broad. GA38 suspends, and I quote, any other statute invoked by any local governmental entity or official in support of a face covering requirement. In other words, GA38 purports to suspend statutes that it does not even specifically identify. What's more, GA38 purports to suspend portions of the Texas Disaster Act itself, the same act that the suspension authority the governor draws on is based on. So you have a surgical suspension using the act to suspend other portions of the act, in addition to broadly suspending statutes that aren't even identified in the text of GA38. Now, this leads to two problems. One, as my friend Mr. Alexander has already addressed, is a problem of statutory interpretation. The grant of authority to suspend statutes under the Texas Disaster Act, which is section 418.016A, is not unlimited. It's not as broad as the suspension that takes place under GA38. And we'll get to that statutory interpretation.
Do you agree that under Chapter 81 of the Health and Safety Code, the Department of State Health Services has preemptive control over the actions of local health authorities and by extension over the actions of other local government officials?
Yes, so Justice Blacklock, we have not briefed the Chapter 81 issue, and it was not briefed heavily by the governor. We are going to take you up on your generous offer to submit some supplemental briefing on that, because that's simply not, at least in the case of the City of San Antonio and Bexar County, the way this case was framed in the Fourth Court of Appeals or on briefing or on petition for review to this court. So that is an issue we're eager to engage with some supplemental briefing. But the suspension authority, Your Honor, if the governor's statutory interpretation, rather than the statutory interpretation adopted by the Fourth Court, advanced by the city, advanced by Bexar County in their briefing, if that is correct, then we go right into a constitutional thicket for the reason that Justice Devine...
Does the governor need the suspension provisions in the executive order to withstand your challenge to that order?
Justice Bland, I believe he does.
Why?
Because there is a grant of authority to the local officials to respond to a disaster that is in many ways coextensive under the plain language of the Texas Disaster Act with the grant to the governor. And that's Exhibit 1 in the handout that Mr. Alexander shared with you. Those 3 parallel chains of command. There is not one chain of command. There is not a unified command structure. There is a judicial chain of command, of which this court is the commander-in-chief. There is an executive chain of command, of which the governor is the commander-in-chief. And then you have a local command structure in which the county judge is the commander-in-chief of the mayors. So those 3 parallel command structures exist in harmony, and what we have here in GA 38 is an ultra vires act by the governor as he tries to extend his control beyond what the plain text of the Texas Disaster Act allows him to do. And essential to that ultra vires action is the suspension, this broad, sweeping suspension of statutes.
Well, if you say there's independent grants of authority and everybody's exercising their authority under their independent grants of authority, why isn't the El Paso court right when it said we have to have a tiebreaker when both branches, both parts of government have the authority and they exercise it, but they exercise it inconsistently? Why isn't it just simply a decision about who gets to make the final decision as opposed to the necessity of suspending anyone's authority?
So here, Your Honor, there's not an inconsistency so much as a limitation that the governor is attempting to place on the local officials. The governor has not, the county and the city attempted to mandate masks within their facilities.
Well, it's an inconsistency on timing, correct? Because are you aligned with your fellow respondents in agreeing that you don't plan to enforce your orders in Bexar County and City of San Antonio right now?
Your Honor, I think that goes beyond the record, but what I would say is the same answer my friend from Harris County gave, which is, as we've seen throughout the last 3 years, this is a dynamic situation. COVID comes in waves. We can't predict what happens next. Hopefully nothing happens next.
Right, but there's just an inconsistency in timing, right? At one point, the governor required masking, and then I think there's a disagreement between local governments and the governor about when the need for that ended. And so are you saying that, for example, the local health authority in San Antonio is requiring it in the school districts? Are you planning to enforce that now?
Not at this time, Your Honor, as far as I know. And then again, I'm a little beyond the record when I say that. I think what this is really about is giving local authorities the discretion, or reaffirming the discretion they've already been given by the Texas Disaster Act to respond as this crisis unfolds, and not preemptively shackling their hands, and allowing what the legislature put in place with the Disaster Act, these 3 parallel chains of command with substantial local discretion to remain in effect.
It seems like your position is that the local authorities can diverge from the governor's wishes if they want to be more restrictive on the population with regard to COVID, but they couldn't diverge if they wanted to be less restrictive.
Your Honor, I think that's exactly right. I think that's a fair point.
How does that make any sense? I mean, this is all a balancing act between concern about the disease, concern about people's liberty, concern about people's constitutional rights. All these things have to be balanced to arrive at what is the best policy in the judgment of the people who the law has given the authority to make that judgment. So I mean, how can it be that this is a one-way ratchet where the locals can always go further, but they can not do less than the state?
Your Honor, I think it's the structure of the Disaster Act itself, and that structure is based on the fact we have 254 counties in this state in a geographic area larger than France. I remember a couple weeks ago.
Maybe another way to answer the question is why don't they have independent authority to do less, to require less restrictions in their jurisdiction than the governor wants? If they do have independent authority stemming from these other parts of the Disaster Act, why can't they use that authority to undermine the governor's orders by requiring fewer restrictions?
Your Honor, I think, again, it just goes back to the structure of the act. The governor is allowed to respond on a statewide basis, and to the extent we have variations in local conditions, a hurricane hitting Galveston County, even as Potter County is completely untouched, there may be statewide implications and regulations the governor wants to loosen in response to that hurricane, but the on-the-ground response in Galveston County is delegated by the legislature to the Galveston County judge.
You said to the extent that there are local variations, who gets to decide whether there are material local variations?
I think that's entrusted to the local officials, Your Honor, where you have, and this is, I think, tab 2 in Mr. Alexander's handout, you have a map of the state at really the height of COVID with different counties in radically different situations.
So let's say the local official decides that this mask business needs to go because it's psychologically problematic for children, for other people, it's inhibiting economic activity, it's a bad thing, we've gone too far with it, and it's counterproductive. That's the judgment of the local official. And he says, under my authority to determine local response, I'm going to eliminate mask mandates because that is the wrong way to handle this. The governor, although the governor has a mask mandate statewide, you're saying that assertion of local power is illegitimate, but the assertion of local power to require masks when the governor doesn't want to is legitimate, and I cannot figure out how that could be.
Your Honor, I'll back off from that a bit because I think the idea is to have simultaneous local discretion even as you have statewide standards. Really, I think if you look at the Disaster Act as a whole, what the governor is empowered to do is to cut state red tape to facilitate and make more efficient the local disaster response. And I just want to...
So would you say that Midland County could have just thumbed its nose at everything in the spring of 2020 because the local officials don't think lockdowns are the right way to respond to COVID?
Your Honor, I do think the governor is empowered to evaluate statewide conditions and to set a state threshold, but local counties simultaneously are empowered to evaluate what's going on in that county. And as my friend from Harris,
opinion, the local government wins over the governor.
For two reasons, Your Honor. Lacking any express preemption in the statute, as my friend from Harris County correctly pointed out, the Disaster Act does not contain the sort of preemptive provision that you would typically see in one of these statutes. And second, this is the constitutional issue that I've been dying to talk about and just haven't had the opportunity to, the suspension issue. The governor has gone too far in suspension, whether it's a matter of statutory interpretation or under Article 1, Section 28, which reads, and I just want to put the language out there for the court to consider since Justice Devine asked about it. It reads, no power of suspending laws in this state shall be exercised except by the legislature. There's no mention of martial law. There's no mention of calling out the militia. That's about as plain English, plain language as it's possible to be. And
none of the courts of appeals got into the suspension clause arguments, right?
Because they went our way on the statutory interpretation
issue. If we determine that it is necessary to reach that, would it not be wiser, the more normal course, to send it back?
Possibly, Your Honor, but it must be dealt with if this court rejects the statutory interpretation that my client has proposed, that my colleagues have proposed, and that all of the courts below upheld.
I ask you just a question about how we determine the idea of when a local government might be more protective, responding to local conditions. If let's imagine that the disaster is something that really does involve ingress and egress. It has to do with getting across the land, and there's something that's gone on with the land that makes it very difficult to escape. And there's a particular kind of shoe that has really great traction and makes it very easy to get across if you can do that. But that same exact kind of shoe also has a huge risk of sinking into the ground and sucking you into the bowels of the earth. Which one is more restrictive, to require it or to ban it?
I like the hypothetical, Your Honor.
Thank you.
What I would say is the county judge enjoys coextensive ingress-egress power under the Disaster Act.
I'm just trying to figure out which one is more restrictive. If the governor insists that people have the shoe and the county judge says, no, that the risk is too great, you're going to sink into into the earth, which one is more protective? How would we even know in that scenario if we were to agree with your premise?
I would say that if someone is moving county to county on an inter-county basis, the governor's order is going to control. If someone is within the county where
the exact same land conditions across all 254 counties, but if they're just trying to get from one place in the county judge gets to decide, but if they're going to step foot across the county line, the governor gets to decide. Is that like an interstate commerce type of Texas interstate commerce, inter-county commerce clause?
Your Honor, I'll try to cut the Gordian knot, that if the Texas Disaster Act needs a tiebreaker mechanism, it currently lacks one, and that's an issue for the legislature to handle. If they need to bake in a tiebreaker mechanism, that may be a flaw in the 1972 Example Disaster Act that the 1975 Texas Disaster Act is based on, given our strong tradition of local government and strong tradition of a weak central government. That maybe the Model Act doesn't deal well with that, and that an amendment is required to clarify what that tiebreaker
if there's no
mechanism
tiebreaker and we need the legislature to tell us how to break the tie, then how are you entitled to a temporary injunction giving you the win as opposed to keeping the tie in place?
Well, Your Honor, I think because of that lack of preemption authority, along with GA 38's sweeping ultra vires suspension of statutes that goes way beyond the text of 418.016A, which is the clause that the governor looks to in the Disaster Act for his very limited suspension authority, his ability to suspend regulatory statutes, his ability to suspend statutes having to do with the conduct of state business. Unless we read regulatory and conduct of state business as surplusage, then 418.016A comes nowhere close to giving the governor the sort of suspension authority that he has exercised or purported to exercise in GA 38.
To know the answer to the constitutional question in order to properly assess the scope of the statute?
I'm sorry, Justice Buzz.
Well, so if, don't we need to know something about, or might we need to know something about whether and the extent to which the suspension clause might affect this in order to decide how broadly or narrowly to read the governor's authority as well as the county's and city's authority under the Disaster Act?
Your Honor, I would just hold the governor to his words in GA 38, where he says that he is suspending, quote, any other statute invoked by any local governmental entity or official in support of a face covering requirement. That's about as broad as a suspension can be. It's suspending statutes that it doesn't even identify. I think this record is adequate for this court to evaluate whether the government has made a proper or an excessive use of his limited suspension authority under 418.016A.
Any other questions? Thank you, Mr. Credible.
Thank you, Your Honor.
Ms. Pettit, I think you have maybe 8 minutes, yes.
Thank you, Mr. Chief Justice. I'd like to start off with a point that this court made in City of Burney, in which it said that the power that the legislature confers are duties rather than privileges. And I think that goes to a couple of points that my friends on the other side had made, including their alleged injury, as well as the points that I believe it was Mr. Alexander was talking about with Justice Blacklock about Section 1015, which says that they have to, as an empowering rather than regulatory provision, every action done under the Disaster Act by a mayor or by a county judge has to be as the agent of the governor. And as you were pointing out, that means that they cannot go contrary to their principles. Second, because the court doesn't actually need, I don't think, to reach that, because at no point in the last 45 minutes or so did I hear an actual definition of what they think force and effect of law means. Now, this court says under Jaster against Comment 2 that where there is an undefined term such as that, the court looks to, among other things, prior interpretations by this court of the same language, and I heard at least two.
Well, surely that provision means that the executive orders have the force and effect of law if the executive orders are authorized by the Disaster Act.
Yes, Your Honor.
Not just anything that might be promulgated has the force and effect of law.
Yes, Your Honor. In fact,
so it's not really doing any separate work. I mean, other than if the orders are authorized by the Disaster Act, they preempt the locals, which I don't know that anybody is disagreeing with.
So the reason why, at least for the city of Dallas, that I heard that they were not authorized by the Disaster Act was simply that they did in fact preempt the locals. They were not authorized by the Disaster Act because they conflicted with local orders, and so therefore they can't preempt local orders. That's circular. So the question then becomes whether the executive order is otherwise authorized, and I didn't hear anybody argue that the Disaster Act does not allow regulations as to masks for good reason, because if it doesn't, then their orders fall as well. And if the Disaster Act allows regulations as to masks, then there is no ability to challenge what the governor's ability to set the policy within that for a couple of reasons. The biggest one is that the ultra vires doctrine, as this court explained in Houston Belt, allows you to police the outer bounds of his discretion, but not how he exercises it. And as a number of you pointed out in the Austin Anti-Defamation League case, this court noted that that is a balancing act that requires multiple different considerations to be taken into effect.
If a mask is a communicable disease control measure under Chapter 81, is that the more specific statute that would control what authority the governor, by extension through the DSHS, would be exercising here? And just, I'm not asking about the specific, but if there was something in there that said you can only do masks under X circumstances, would you be arguing that nonetheless under the Disaster Act you can require them in circumstances beyond X?
So the specific versus general distinction, I think there has a couple of different axes which are problematic, which is that would definitely be the more specific provision outside of a disaster circumstance because it deals specifically with masks.
Well, it's public health disasters is what Chapter 81 deals with.
That's true. There's also other elements of that particular chapter. But yes, it would be dishes, but as a number of you pointed out, that would be under the governor's governor's control as the commander-in-chief. But the more specific aspect to it is also, I'm sorry, I'm not sure where I was going to go with that thought, but it could be the more specific one, but that's also, I think, I now remember, it was where the suspension aspect of the Disaster Act really comes into effect. We don't think you need to get to it, Justice Bland, because of the preemption element, because this is a local order. But the suspension provision says when there are multiple different state-level laws, and you have to pick between the two of them. There are various different rules of construction. The general versus the specific is one, which was enacted later versus earlier is another. There's different canons. And the suspension clause allows the governor to say, notwithstanding those canons, if there's a conflict between my executive order and this law which I have suspended, you should apply the executive order anyway. And so that's where I think the effect of the suspension really has an impact, is that when it becomes to state laws, whereas if there is a conflict between state and local laws, that's preemption, and that's going this way.
Is there any limit of duration that we ought to think about in terms of the constitutionality of these sorts of declarations and orders? And I'm imagining a scenario. Let's say the governor waits until the day after the legislature leaves town and says, I'm declaring a disaster, and the disaster is that climate change is going to destroy the world, and my solution to that is that everybody has to stay home and not drive their car on Tuesdays and Thursdays. Does that, and is that's ingress and egress, that's the movement of persons. Everything we do potentially has some impact on climate change, and so this all-encompassing disaster that's everything is germane to it. Does the governor have that power, for the year and a half in between the legislature leaves and when they come back, and he decides whether to call them back? He doesn't, so he just asserts this power for a year and a half. And
so there are certainly a lot of political checks on that, but to answer what I think the specific question is there's no time limit in a delegation context, because a delegation is a facial challenge to the statute, not an as-applied one. And the facial the limits on the statute are not written in terms of time, in part because disasters can have different lengths. How long it takes to get over an extreme heat disaster would be very different from how long it would take to get over, say, something on the scale of Hurricane Katrina. And so as a result, the timing is very, very fact-specific and not pretty conducive to deciding in a facial challenge on a non-delegation issue. The delegation...
Could another governor use this act to impose the kind of thing that I just described?
So it would be very difficult, I think, for them to fit that into the definition of disaster, but it's a larger issue.
That all depends on your perspective. A lot of people think it's an imminent disaster, we're all going to die, but that's not solved in the next 10 years or whatever. And the governor thinks that, right? And his judgment genuinely thinks that. Can he do what I described?
So could you repeat what exactly the hypothetical was? He declared a disaster based on global warming, and then he used it to limit under the limit
we need
car
to
use.
We need to have less emissions, and so everybody needs to stay home on Tuesdays and Thursdays. No driving of cars on Tuesdays and Thursdays.
So I think that would have some pretty severe 14th Amendment freedom of travel problems, and I don't think he could do it for that reason. There's nothing.
And the lockdowns didn't?
So the lockdowns were limited. So the 14th Amendment freedom of travel is subject to some limits that I think would be hard to meet in that particular hypothetical, because the nature of the disaster that Your Honor is deciding is one that is not particularly subject to proof, whereas quarantines are an accepted ground, or quarantines under limited circumstances or a lockdown under that would be much easier to show a sufficient government interest to evade or to meet the 14th Amendment right to travel test. Your Honor, can I finish one quick point for Justice Bland? You've asked a number of questions that go into the effect of, are we asking for an advisory opinion? I agree with my colleagues that there is a live controversy here, because they are insisting on continuing to have these orders in place that could put Texans in masks at any given point. And that is something that the governor thinks, and his ability to control the economic recovery period is not appropriate. However, if the court disagrees with that, I would strongly urge that the court still vacate the decisions below under Marath against Lewis, which allows for that relief in instances where the public interest requires to clear the road for future litigation, as I believe the phrase this court used on page 790. And that is certainly the case here, where we have 3 courts of appeals who have decided much broader than mask issues about the governor's ability to set rules when there are hurricanes, tornadoes, and oil spills. And that, in those circumstances, there needs to be the ability to decide his authority under the Texas Disaster Act.
So the legislature can read the suspension clause just as well as we can and have their own view about its scope and what they choose to allow to be suspended and not in light of that. So do we need to think about the suspension clause in deciding how broadly or narrowly to read the textual limitations in 418.016 and 418.018 regarding the procedures for the conduct of business and regarding ingress and egress?
So, Your Honor, normally, if I understand the question, the court goes in the opposite direction, where it interprets a statute to avoid a constitutional problem rather than interpreting the Constitution to go into the to determine the scope of the statute.
But do we need to look at the Constitution to know whether there's a problem?
You should look at the Constitution to know whether there's a problem and whether it needs to be interpreted narrowly if you disagree with us on our preemption argument. I would point this court, if you're looking to that, which I think you might find useful, is Professor Braden's work from 1972 that this court has previously looked at in the interpretation of the Constitution pretty regularly. I think it's particularly useful in this case because it's roughly contemporaneous with the Disaster Act, so it would have been how the legislature understood the word suspension, which is what I think Your Honor is getting at. And Professor Braden's view is that the suspension provision doesn't do much at all because it is a partial restatement of the separation of powers clause. And so under that view, there's not a suspension problem here.
Any other questions? Thank you, Ms. Pettit. The case is submitted, and the court will take a brief recess.